The journey toward the Employment Rights Act 2025 began as a core policy pledge to overhaul the UK's labour market. Originally introduced to Parliament as the Employment Rights Bill, the legislation was designed to deliver the most significant upgrade to worker protections in a generation. On 18th December 2025, the bill received royal assent, officially becoming the Employment Rights Act 2025. While the law is now on the statute books, the transition is phased, with the majority of substantive changes expected to take effect from autumn 2026 through 2027. The primary intent of the Act is to provide immediate security for workers while balancing the flexibility modern businesses need. It seeks to close legal loopholes, such as those used in fire and rehire practices, and to ensure that rights like sick pay and protection against dismissal are accessible from the very first day of employment, rather than after years of service. The most significant shift is the reduction of the qualifying period for unfair dismissal claims. The current 2-year requirement will be slashed to just 6 months. This effectively transforms how businesses approach recruitment and probation, as employees will gain full protection against unfair dismissal much earlier in their tenure. To ensure employees have sufficient time to seek justice, the time limit for bringing a claim to an employment tribunal will double, moving from 3 months to 6 months. This gives businesses a much longer tail of potential liability following any termination. The Act introduces a new category of automatic unfair dismissal to prevent fire and rehire tactics. Employers will only be permitted to change contractual terms without consent in extreme circumstances involving urgent financial distress. Failure to follow strict consultation processes can lead to significant financial penalties per employee. The threshold for collective consultation is becoming more stringent. Instead of looking at redundancies at a single establishment or site, the count will eventually apply across an entire organisation. This means SMEs with multiple small locations must be far more diligent when planning staff reductions. Flexible working is becoming the default. Employers will be legally required to grant requests unless they can prove a genuine, reasonable business reason for refusal. The burden of proof shifts heavily toward the employer to justify why a role cannot be performed flexibly. The Act removes the waiting days for sick pay, making it a day one right. Furthermore, the lower earnings limit is being removed, ensuring even the lowest paid workers are eligible. For those on 0-hour contracts, the Act introduces a right to a contract with guaranteed hours if they work a regular pattern over a 12-week period. The legislation makes it significantly easier for unions to gain recognition within a workplace, lowering the membership thresholds required for a ballot. Employers will also be required to explicitly inform every new starter of their right to join a trade union. A new enforcement body, the Fair Work Agency, will have the power to inspect workplaces, seize records, and fine businesses that underpay staff or breach holiday pay rules. This marks a shift toward proactive state enforcement rather than relying solely on individual tribunal claims. For organisations, the Act represents a period of necessary adaptation. The financial cost of employment will rise due to day one SSP and the administrative burden of managing more frequent flexible working requests. Recruitment must become more precise. With the unfair dismissal window closing at 6 months, the wait-and-see approach to new hires is no longer viable. Owners must ensure their contracts, handbooks, and management training are updated well before the 2026 deadlines to avoid the reach of the Fair Work Agency. For the workforce, this Act provides a level of stability previously unseen in small and medium-sized enterprises. Employees gain the confidence to request flexibility, and the security of knowing their income is protected by guaranteed hours and immediate sick pay. The extension of tribunal limits and the removal of the 2-year wait for dismissal protection mean that employees are no longer at will during their first years, fostering a culture of mutual respect and long-term commitment.